Hi, good afternoon. My name is Alicia Field. I'm the Director of Events for the Greater Reston Chamber of Commerce, and I'd like to welcome you to today's Business Success webinar, Beyond COVID-19, Getting Back to Business. And before we get started, I'd like to quickly recognize our annual sponsors, who you'll see here on our screen, our strategic sponsors, our visionary sponsors, as well as our advocate sponsors. Now I'd actually like to thank our founding sponsors of this webinar series who make it possible today to bring you this programming. So first, BEI, who you'll hear from later today, and also the Reston Community Center. And we have Lila Gordon here, the Executive Director of Reston Community, to say a few words. Lila?
Thank you, Alicia. It's a pleasure to be with the Greater Reston Chamber of Commerce today. We're very proud of our relationship and partnership with GRCC. We extremely value our connections to Reston's business community, and we wish everybody in that community wellness and safety as we navigate the pandemic together. Reston Community Center extends its benefits to both residents and employees of Reston-based businesses. We encourage you to visit our website, restoncommunitycenter.com, to find out about all of the enriching experiences that we offer. We're hoping to reopen our facilities in July, and we look forward to welcoming you to them and to our programs and services. We're very grateful to the business community and to the Greater Reston Chamber of Commerce for this opportunity. Thank you.
Wonderful. Thank you so much, Lila, and thank you to the rest of the Reston Community Center as well. I really appreciate it.
Our pleasure.
Now on to our presenter. We're very pleased to have Doug Taylor, who's a shareholder with Bean, Kinney Korman, joining us today to share some important advice on how to manage your business and employees in a post-COVID-19 environment. So please, go ahead, Doug.
Thanks, Alicia, and thanks to the Reston Chamber staff for the opportunity to talk today. Happy to be here to talk with you briefly about the prospect of returning to work and what that will look like. I'd like to give a big thanks also to Bean Kinney's marketing director, Chris Sutton, for putting together the materials for today's presentation. With everything changing as rapidly as it has, that was no small task. So we're going to talk for a little bit today about COVID-19 and the dramatic impact that it has had on public health, and for our purposes, the impact that it has had on businesses throughout Virginia. Bean, Kinney Korman is going on week 7 of remote work status. God, it feels like a long time. And like you, we are looking forward to getting back to something that looks a little bit more like business as usual, or whatever that new business normal looks like. So we're going to talk briefly today about Virginia's response to COVID-19, how we got from there to where we are right now, the return to work safety expectations that you should start thinking about, the EEOC's do's and don'ts for COVID-19 medical inquiries of your employees and medical testing. We're going to touch briefly on the new paid sick leave and extended family medical leave law. Talk briefly about Department of Labor and IRS record keeping related to the new leave. And also finish up with just a brief overview of some business insurance options. Next slide, please. So Virginia's response to COVID-19 way back when, back in the second week of March, Governor Ralph Northam declared a state of emergency in the Commonwealth due to the COVID-19 outbreak. 11 days later, he issued a second executive order, which was pretty substantive. It closed public and private schools for the rest of the school year, limited the size of public gatherings, closed restaurant and food establishments to takeout and delivery, closed recreational and entertainment businesses, also closed a wide range of other businesses that had some difficulty establishing social distancing, such as barbershops, fitness centers, and the like. It also allowed some essential businesses to remain open while this is all going on, while utilizing appropriate social distancing and sanitation measures. Then on March 30th, Governor Northam issued what I call the stay-at-home executive order, which limited individuals from traveling outside their their home for anything other than essential services, one of which was, as you know, traveling to and from work for essential businesses. So since the end of March, we have been in sort of a semi-lockdown situation for many of us and many businesses. And so it was a welcome note last Friday that Governor Northam held a press conference where he presented what he called phase 1 of his plan to lift public restrictions in Virginia. No specific time frame was given for implementation of phase 1 that's likely to depend on the level of COVID-19 infection, but it's clear it's going to still keep social distancing in place. In some instances require remote work where that's available, wearing masks in public and the like. Some businesses are going to have to remain closed under phase 1. Other businesses will be allowed to reopen, some of them with restrictions to ensure public safety. So while it's too early to predict an exact date when businesses can look forward to sort of reopening again and what that might look like, it's not too early for us to start talking about what your return to work plan should look like. Importantly, workplace safety has become a huge issue, as most of you know, with the COVID-19 outbreak. The Washington Post reported last week that workers have filed thousands of unsafe workplace complaints with the Occupational Safety and Health Administration, claiming that they've been subjected to unsafe work conditions. And while it seems like the volume of work is going to keep OSHA only focused on the larger or more significant complaints, nevertheless, those kinds of concerns present some risk for businesses like yours. Next slide, please. So we're going to talk about OSHA first. OSHA, as many of you know, is the federal agency responsible for administering federal workplace safety regulations. Next slide. And the main, the main safety standard that we are going to be looking at and thinking about today is the general duty standard, which requires employers to provide employees with a workplace that's free from recognized hazards likely to cause death or serious physical harm. And so the question has been whether or to what extent COVID-19 presents a hazard likely to cause death or serious physical harm. OSHA and the CDC have concluded that it does present that kind of risk, and OSHA has issued some guidance to help employers prepare their workplaces in the COVID-19 environment. And so we're going to be talking about that OSHA guidance. It's clear it's not a legal standard and it's not a regulatory standard. But I would say from my vantage point that I think the guidance presents what you might want to consider as sort of a floor for safety measures that you should consider adopting for your particular workplace. Certainly very helpful recommendations on what you can consider. So the OSHA guidance contains safe workplace infection prevention practices, some policies and procedures for prompt identification, isolation and removal of sick employees, talks about implementing workplace controls, lots of deference to the CDC there as far as safety guidance is concerned. And other administrative controls and sort of guidelines for personal protective equipment for employees. Next slide, please. One more slide, if you could, please. Thank you so much. So what we're going to talk about in terms of OSHA's safe workplace guidance is really tied to this, this wonderful graphic you see on the screen now, which is the occupational risk pyramid. So as you can see at the top of the pyramid are very high risk work environments that typically entails healthcare workers who provide direct patient care and emergency medical personnel, where they're working in a high risk environment because there is a greater likelihood of COVID-19 exposure and very close proximity to sick patients. Next down is a high-risk environment where you're talking about healthcare workers that sort of deliver secondary services, support staff, and so forth, but they're still in the healthcare environment and still exposed to a higher level of COVID-19 infection. Medium risk is really the category that contains a lot of retail jobs that we think about, jobs that require frequent or close, sort of less than 6 feet contact with the public or with coworkers. And then at the bottom of the pyramid are low risk work environments where there is no frequent or close contact with the public or with coworkers. So when you think about the relative level of risk for your work environment, it's good to factor these safety suggestions through this risk pyramid to determine sort of where your workplace falls in that spectrum. So next slide, please. So the OSHA guidance, as I mentioned earlier, but it's worth mentioning again, relies on CDC guidance that you can find on CDC's website. We have all these documents linked on Bean Kinney's website as well. If you have trouble finding them, they're available there. The CDC is really interesting because it has safety guidance broken down by particular industries. I had a need to look at the safety guidance for food and retail workers and found the guidance there to be very helpful. And so you may want to take a look at that for your particular industry. The OSHA guidance contains sort of, try to break these down into categories, but one category is sort of basic preventative measures that really are applicable to all workplaces, irrespective of the risk there. And this entails things like continuing to require social distancing of your employees and also of your customers in relation to those employees. Continuing to require and promote proper hand washing, providing your employees with education, how to wash their hands. And I know it sounds like we do it all the time, but there is a way to do it. Provide frequent workplace reminders on the value of washing hands and provide appropriate hand washing supplies. Encourage your employees to adopt coughing and sneezing etiquette to avoid spread of COVID-19 infection. Provide your customers with hand sanitizer, tissues, and trash receptacles as appropriate. Discourage your employees from sharing office desks, computers, phones, tools, and equipment where common touch surfaces can facilitate the spread of COVID-19. Discourage face-to-face meetings in the office. We're using virtual means today, and we're happy to have that. And we are going to have to get used to virtual meetings to a larger extent in the future than we probably have in the past. And the last one is to establish regular office housekeeping, cleaning, and disinfecting as may be needed. The next category of sort of OSHA things to think about are sort of related to your workforce options and what you might want to consider there to limit your safety risks. One would be to continue to consider remote work options. We have been completely remote as a law firm for the last 7 weeks, and with a few bumps, it has worked out remarkably well. So for those business models that remote work fits, the strong suggestion is that you should try to continue that while we're working through the COVID-19 risks. Use flexible or staggered work shifts. It will allow you to have fewer employees in your workplace at any one time. You could think about adopting alternative day work schedules, which you know, in essence would cut your employees in the workplace in half at any given time. Encourage or require your employees to wear face masks as a condition of returning to work. Those things are really applicable across all workplaces. So the last category of concerns that OSHA addresses, really I call brick and mortar type improvements to promote workplace safety. And that would involve things like using high efficiency air filters for your office, increasing air ventilation rates in the office, erecting physical plexiglass sneeze barriers as needed, Consider drive-through and remote customer service options if those fit your particular business model. And in those high-risk work environments, require your employees to use PPEs, gloves, goggles, face shields, and respirators. We're going to talk a little bit about what OSHA sort of considers identifying sick employees and what do you do when that happens, and how to get them out of the office as quickly as you can to minimize the spread of COVID-19. One way that you can do it is you should have a policy and tell your workers often that they should stay home if they're experiencing any COVID-19 symptoms. Tell them also, stay home if you have a family member who is experiencing COVID-19 symptoms. Check your leave policies. You'll want to consider being a little bit more flexible in terms of how you apply your sick leave policy while the COVID-19 pandemic is ongoing. There are two primary reasons for that. One is that it's a little bit more difficult for your employees to get adequate documentation for the need for sick leave with healthcare being sort of at a premium in some ways at this point. And the other way too is that there's a benefit to you and the business of not having your workplace infected and the specter of having to close down completely in order to abate that. Be sure that your sick leave policy has been updated to encompass the new Emergency Paid Sick Leave Act and the new Extended Family and Medical Leave Act. And those are going to be important. We'll talk about those in a minute. Next slide, please. So when we talk about how do you identify sick workers, we have to start talking about the EEOC. The EEOC, as many of you know, is the federal agency responsible for the federal EEO laws. And one of those EEO laws is the Americans with Disabilities Act, which under ordinary circumstances prohibits medical related inquiries and medical examinations in the workplace. That is unless, and what we're going to be talking about today is whether a medical condition poses a direct threat to the employee or to those around the employee. And so we're going to talk about that concept of direct threat. And because the EEOC has decided that COVID-19 does pose a direct threat to individual employees, the EEOC has also decided to adopt a more flexible approach, excuse me, to what you as an employer can ask your employees about their COVID-19 health issues. One thing to keep in mind is the EEOC has made it really clear that they are going to be reassessing this flexibility as risks of COVID-19 lessen. So you're going to have to keep an eye on this, and what you can do right now as far as what you can ask of your employees may change at some point in the not too distant future. So the EEOC has published some guidance, some pandemic guidance that provides some sort of do's and don'ts as far as what you can ask and what you should consider doing in a pandemic situation. They also more recently issued a couple of technical assistance bulletins, which sort of in a Q&A format kind of go through some of the questions that, that they must be getting most frequently from employers, and certainly ones that I'm fielding most frequently as of late. And we can go through a few of those now. Essentially, they relate to how much medical information can an employer request from an employee who calls in sick or exhibits signs of sickness related to COVID-19. Because of the current pandemic, employers can ask employees if they are experiencing influenza-like symptoms, such as fever or chills, and a cough or sore throat. It's not a license to ask your employees generally about their health. So when you think about what you're looking to ask them about, it's typically going to have to be limited to those symptoms and those conditions that are identified as relating to COVID-19. An important reminder in this area is if you are either receiving or asking your employees for medical information, you have to maintain that information separately, and you have to exercise good confidentiality controls over that information. So you are allowed to ask employees who are reported feeling ill at work or who call in sick questions to determine whether they may have COVID-19. During a pandemic, may an employer ask an employee who does not have influenza symptoms to disclose whether they have a medical condition that the CDC has said could make them more vulnerable to coronavirus complications? I'm thinking primarily of that the coronavirus has seemed to have a more significant impact on age-protected workers. And so the question really becomes, can you, without that employee exhibiting any symptoms, can you ask about that? And the answer is you can, just because of the serious nature of what is going on with COVID-19. The EEOC is going to adopt the CDC's guidance, which is to allow as much flexibility as you can to anticipate issues that could come up and thereby allow you to maintain a safe workplace and promote safety for your workers. Next slide, please. So one question that has come up a bunch for my clients: can I take the body temperature of my employees while this pandemic is going on? And the answer is yes. Although taking an employee's body temperature is a medical examination and would ordinarily be restricted under the Americans with Disabilities Act, while coronavirus is ongoing, the EEOC is going to allow that kind of testing. And as many of you know, a number of large retailers in particular have adopted mandatory employee body temperature testing. Again, take special care of the test results and other information that you might get regarding your employee's health. Can an employer require an employee to submit the COVID-19 testing before permitting them to return to work? And the answer is yes. This, for the EEOC, this was, they were kind of a latecomer to this. I just kind of stepped out on this, I think it was last week, and finally said, yeah, we think that at least some kind of testing is okay, given where we are with coronavirus. It's not clear that all tests, I guess depending on the invasiveness of it, would be acceptable, but it feels like now we're on the verge of having some tests that may be easily administered and readily available, so that I would anticipate that that employee testing of this kind will become a lot more regular than it is now. Next slide, please. So can employers require employees to stay home if they have COVID-19 symptoms? The short answer is yes. Can you require a doctor's note when an employee returns to work, certifying the employee's fitness? The answer is yes, because we've got this pandemic situation and there is a lot more flexibility in that regard. Next slide, please. And this is an issue that has come up for me a fair number of times over the last couple of weeks, where an employer will learn that an employee has been infected with COVID-19, and so then the question is, do I have to keep their name confidential, or how do I alert other employees to the fact that they may have been exposed? So the short answer is you can disclose the employee's name, the infected employee's name, to a public health agency without obtaining any authorization from the employee to do that. But as far as whether you can disclose a name more generally in the workplace as a part of your notice to other employees, the answer is no, you shouldn't do that. You can ask the employee for authorization to disclose their name, and we have developed some authorization forms. If you have any need for that, feel free to reach out to me. That would, that would allow that to happen. But otherwise, you're going to have to provide a more generic notice to your employees that does not name the infected employee, but still allows you to get the word out that other employees may have come into contact with an employee who was exposed or who has come down with COVID-19. Okay, and let's see if we can fast forward to one more, please. How about we're going to go to paid leave? Yeah, here we go. So thank you very much. So as most of you know, back in March of this year, Congress passed the Emergency Paid Sick Leave Act, which requires employers to provide eligible full-time employees with up to 80 hours of paid sick leave. There are caps on the per day rate and caps on the total amount of that paid sick leave benefit that when the employee is unable to work because the employee is subject to a federal, state, or local quarantine or isolation order, has been advised by a healthcare advisor to self-quarantine for COVID-19 related reasons, is experiencing COVID-19 symptoms, and is seeking a medical diagnosis, and when the employee is unable to work because of the need to take care of an individual subject to an isolation or quarantine order. And the last one is the need to take care of the employee's child who is out of school or child care because of closure related to COVID-19. Also passed was the Extended Family and Medical Leave Act, which allows certain qualified employees, it's those employees who've been on your payroll for 30 days or more, to take up to 12 weeks of expanded family and medical leave. Typically, as you know, family and medical leave is unpaid. Under the Extended Family and Medical Leave Law, 10 of the 12 weeks are paid leave. There is a capped per day rate and a cap on total benefits that are available. This benefit is limited and only available to eligible employees who are unable to work or telework because of the need to care for the employee's child whose school or place of care is closed for COVID-19 reasons. Employers are eligible for a tax credit for paid sick leave that's offered to employees. And I will leave it to my tax colleagues to weigh in on exactly how that tax credit refund works, but it is available and it appears to cover most, if not all, of the paid sick leave that you may pay out, and it is worth looking at those the particulars of that. In order to avail yourself of those tax credits, though, there are some record-keeping requirements that you're going to have to comply with, and we're going to talk about those really briefly. Let's see, there really are two sets of record-keeping requirements. The Department of Labor and the Internal Revenue Service have separate sets of record-keeping requirements. There's a lot of overlap between them. They come up for really completely different purposes, and so you can sort of sort through what you would need to do in order to comply. Department of Labor issued temporary regulations to implement the new laws that were passed in March of this year. The temporary regulations spell out what you need to do in order to comply with the new laws. And there are record-keeping requirements. Your employees are required to provide you with documentation relating to a request for paid leave. And this is on the employee to provide to you, but you have to ask them for it, and they need to provide it to you because you need to maintain these as your record moving forward. It entails the basic things like the employee's name, the dates for which leave is requested, the qualifying reason for the leave, and an oral or written statement that the employee is unable to work for the qualified reason. And just a brief sidebar, if the employee gives you an oral statement that's okay, but you as the employer have to commit that to writing and keep that in your file. It's not enough to just to recall that the employee gave you an oral statement. You need to have something in writing. So if the request for sick leave is because the employee is subject to a quarantine order, the employee also has to give you the name of the government entity that has issued the quarantine or isolation order. If sick leave is taken because the employee has been advised by a healthcare provider to self-quarantine, then the employee also has to provide you with the doctor's name who has made that recommendation. If sick leave is being requested because the employee is unable to work to care for an individual subject to a quarantine or isolation order, the employee needs to provide you with the government entity who issued the order and the name of the healthcare provider who advised the individual to self-quarantine. Paid sick leave taken is the need to care for a son or daughter whose school or place of care is closed. Is required to provide you with the name of the son or daughter, the name of the school or place of care. And this is kind of an important one, a representation that no other suitable person will be able to care for the son or daughter during the time period for which leave is taken. And I've had this come up a few times for clients who either have strong reason to think that there may be another option. Why can't the spouse, why can't the employee's spouse take care of the child rather than me paying out sick leave for this? And there may be some instances where you have reason to to wonder whether that's the case. But I think under the current circumstances, you're going to have to allow some flexibility there in terms of that. And it seems to me for Department of Labor record-keeping requirements, that statement, that representation from the employee is really important because it will give you cover in the event that it turns out that there were some other options for the employee. The regulations allow you to ask for such other materials as you might need to document the request for leave. I'm not really sure what that entails, but you do have some leeway there to do that. And there are some employer record-keeping requirements that both the Department of Labor and the Internal Revenue Service have for you as an employer. The big one is you have to maintain all documentation for 4 years at least, and that is regardless of whether the employee's leave was granted or whether it was denied. Again, if the employee has provided you with oral statements, you need to document those in writing. An employee denies a request for leave, you've got to maintain that documentation for 4 years as well. To claim a tax credit from the IRS, also the IRS's time frame for maintaining those records is 4 years. The IRS has sort of a different set of requirements. The Department of Labor is really looking to this documentation to ensure if there is a dispute about whether you implemented the paid leave laws correctly, that you've got a documentary record when the Department of Labor comes to investigate. The IRS, on the other hand, is really mostly concerned with your written record when they're looking at whether you're entitled to some or all of the employer tax credit for paid leave. And that entails a documentation showing how you determine the amount of paid sick leave that you gave, that you offered, or expanded family and medical leave, including work records, telework records, and paid sick leave and expended family and medical leave. So it's pretty much the whole universe of your employee work records, really, it seems to me, in order to be sure that you've got proper documentation to respond to an IRS audit if that unfortunate occurrence were to happen. Documentation to show how you determine the amount of qualified health plan expenses that you've allocated to wages for purposes of the tax credit, and copies of any completed IRS forms. I'll leave those to you to discuss with your CPA or other tax advisor, and any other documents that you would need to support your request for the tax credit. Also, too, there is this idea that, and some of you may have exercised this, there is a small employer exemption to paid leave, and a small employer is defined at an employer with less than 50 employees. And if there's a showing of that your business would not remain viable if you had to provide paid sick leave and then seek the tax credit later on. If that would affect the viability of your business, you should maintain the records that you rely on in order to assert that small business exemption to providing paid sick leave. Next slide, please. Okay, to close things up here, we're going to talk about covering your business against coronavirus related losses. Many of you over the last couple of months have probably maybe for the first time or one of the few times have sat down with your insurance policies and looked at them really closely to see how they might provide you with some recoupment of losses to your business caused by the COVID-19 pandemic. If you haven't done that, now is a terrific time to do it, a terrific time to reach out to your broker to talk about what your insurance is and what it might do for you now and what you might want to think about for the future. And as with all things insurance, whether you have insurance or whether there are exclusions that put you outside of your insurance coverage is really dependent on your particular insurance policy. So the things that we talk about here in terms of generalities may or may not be completely applicable to you because of the terms of your particular policy. The big one for workplace issues is workers' compensation insurance. It generally, virtually all Virginia employers are required to have it. It generally applies to injuries or illness arising out of or occurring within the scope of your employee's employment. It's generally applicable to remote work situations as well. The factors in determining scope of employment for workers' compensation insurance are when and where the loss occurred and what the employee was actually doing at the time of the loss. It is not entirely clear at this point whether in the context of workers' compensation insurance, whether or to what extent coronavirus-related illness is a compensable workplace injury or illness. So we'll have to stay tuned for more on that. We're still fairly early on there. Many of you have business interruption insurance that you may be thinking about making a claim under. Typically, this is coverage that you have to cover you for losses, direct physical losses to your business property, typically caused by things like hurricanes, fires, wind, theft, things of that nature. So the question comes up, can the mere presence of coronavirus be considered that kind of direct physical damage to your business property? Infected work surfaces, surfaces infected by coronavirus? It's not clear. There are a lot of differing opinions about whether to what extent coronavirus losses are covered under business interruption policies. I would say the weight of evidence at this point is that business interruption coverage typically will not cover coronavirus related losses. But that doesn't mean that you shouldn't make a claim under it because you never know. It may be covered under your policy. There's also contingent business interruption insurance to cover damages for things like direct physical losses to a major supplier, a major customer of yours that work their way back to you and cause you economic loss. So if you have that kind of insurance, consider whether it would be appropriate to make a claim there. For those of you who have event-driven business models, many of you have an event cancellation insurance or should consider that. It's specialized coverage that basically goes to covering losses related to the cancellation of events, sports events, entertainment, conventions, and the like. As with many kinds of insurance, there are often exclusions from coverage for infectious diseases. And now we're seeing a lot more exclusions related to coronavirus. The last kind of insurance we're going to discuss is CGL, commercial general liability insurance, which most of you have. It's designed broadly to cover your business for losses related to bodily injury and property damage. It is not clear in all instances whether COVID-19 related losses would be covered under CGL policy, but it is certainly worth making that kind of claim if you have the coverage, because it may be covered. And even if it isn't, insurers typically have two separate duties to you as the insured as a part of CGL coverage. One is the duty to cover you for losses given the wording of the policy. And the other duty is to defend you against loss claims, which can entail a legal defense, and legal defense can often be costly, and so that can be a valuable benefit, even if it turns out that the insurance carrier sort of reserves its right to cover the loss as a matter of the policy. So that is a whirlwind tour through the world of return to work. I would say, would recommend that you take a look at 3 documents. One would be the OSHA guidance for employers. It's available on the website, very easily readable, provides a lot of great guidance. I'll read that in tandem with the CDC's guidance for employers, which talks about workplace safety, and the EEOC's pandemic guidance, and also the technical assistance bulletins that have come out. And I wish you all well moving forward. If you have any specific questions that we don't cover today, feel free to reach out to me. I'm always happy to talk with you. Now we can take questions if anybody has them.
Sure, absolutely. Thank you, Doug. We've got a question from the audience. It says, to reconcile the increased flexibility of employers to inquire on an employee's health, including temperature checks, with their requirement to maintain privacy, are there recommendations and/or requirements on steps to modify the office layout to facilitate such actions?
I think that makes sense on a couple of different fronts. Again, most of the things that we're talking about today are, we're talking about generalized guidelines. I wouldn't say that these are legal standards per se. Either you have to do this or else you have committed some sort of violation. But really what they are is sort of either individually or cumulatively recommendations that you should consider. Safeguarding employee privacy when you're talking about health-related inquiries or testing would be an important consideration. For a couple of different reasons. One, because it protects the privacy that goes along with that kind of testing. And it also can provide a little bit more space, separation between your employees when you're trying to determine whether you have any employees who have been infected with COVID-19.
All right, that makes sense. Thank you. So for temperature checks and things like that, you might just want to certainly do it at the entrance before they even come in, have something for that. And then I guess also, like you said, it's guidelines, but whether it's in the conference room and having a space between each chair, or perhaps if it was a bullpen type environment, in some way, trying to maybe add more chairs or something like that, again, to space people out. So nothing specific, always guidelines.
That makes sense, and there aren't any specific guidelines other than to say that employee privacy when it relates to medical information is important. I think it depends a lot on the kind of workplace that you have, the particular layout that you have, but really, given where we are with things and given that we seem to be on the verge of some changes, is sort of loosening the return to work, now is a good time to consider your office layout and what you could do in terms of, that kind of testing.
Right, absolutely. So a good combination of things. So a lot of these things you've mentioned are certainly guidelines, some of them, to protect privacy and things like that. Do you think that these are things, again, protecting privacy, the guidelines that might need to be put in place, are those things that you feel employers will have to put out before people come back to the workplace? Or are they sort of things that they can do real time as people come back? Like, do they have to prepare people for these things? Do they have to feel any liability if they don't say it beforehand? Or do you think it's something that they can do on site as they come back in?
That is a really good question. And I think as a general or a best practice, it would be a good idea for employers to develop return to work policy and let your employees know in advance of that anticipated time of return to work what the expectations will be. Because you are going to have some situations where you are going to have employees who may have some special needs for medical reasons, for disability reasons. Once you put out your guidelines for return to work, are then going to reach out to you to sort of express those concerns that will help you to be able to work through those in an orderly fashion without the need to try to do that in sort of the crush of the moment of trying to, reopen the doors, if you will, and get a new policy implemented. So anything that you can do in advance, I think, would be appreciated. And yeah, in a sense, I mean, if you think about it, I know as a law firm, we have already started thinking about that and have already circulated a policy. Typical lawyer fashion has been open to, comment. And I would imagine that those comments will, result in maybe some changes in the policy that ultimately ends up being issued. So there could be a benefit there as well.
Okay, wonderful, wonderful. Thank you. It looks like we're through all of the questions. So do you have any last remarks before we close?
No, I think that's it. Just all the best. Like me, I'm sure that you are anxious to jump back into the workplace. And when you do it, think about it in advance. Try to create as many safety things as you can. The ones that are really important are the ones that you sort of can do as a matter of education and sort of easy compliance. For the ones that we talked about, the basic measures, consider those just no matter what kind of workplace that you have, because I think they're going to be the expectation moving forward, and they may well turn out to be the requirements.
Okay, wonderful. Well, thank you again, Doug, so much for your presentation. This is incredible information. It's going to be great to have this on hand as we prepare to transition back. So thank you all so much. We appreciate your time and being Kinney Korman, and again, Chris Sutton for putting this all together for us. And of course, before we wrap up, I'd like to invite Ellen Jennings, who is the CEO of BEI, who's another one of our founding webinar sponsors, to say a few words as well. Ellen?
Thank you, Alicia, and thank you, Doug. We're looking forward to, to getting back together to work, and this was really great food for thought about how that's all going to happen and how it will play out. So, I really appreciate the time that you spent putting this together. BEI is an IT support firm. We have provided support for the Reston Chamber since 2009, I believe. Long time ago. We have clients in sort of every market segment in terms of professional services. We have a lot of GovCons and a lot of healthcare practices. So we do a lot of work around compliance and around security. We'll be sending out some resources in the email that Alicia's going to follow up with that has some of that information. We spent a lot of time, we were crazy busy at the beginning of this, moving, making sure that all our clients were set up and working from home, and that is happening securely. So, one of the things that keeps resonating in my mind is that, bad guys thrive in bad times. And there's a lot of reason to keep security top of mind right now. So whatever you can do to keep your employees focused on, watching their email, don't click on that link unless you know where it's from. Maybe take the time to do a little extra IT security training or a fake phishing campaign. That would be time well spent now, because there's just a lot going on. So with that, I'll close. It looks like it's going to be at least a gorgeous Saturday. So I hope we all can get outside and enjoy, enjoy the real world a little bit, get away from the screens, and thanks to the Chamber and to Bean Kinney.
Thank you again, Ellen. We certainly appreciate your support of the Chamber and BEI as a whole, and thank you for being a founding sponsor of this webinar series. And thank you to Reston Community Center as well for this. And again, thank you to Bean Kinney Korman